Namaskar. Welcome to the discussion on human rights, NGOs and statutory bodies. Friends, to start with, the term NGO has no specific definition but denotes any non-governmental organization formed by a group of people, and there are innumerable NGOs which are formed and is permitted under the Constitution of India in Article 19, Clause 1C, providing that all citizens of India shall have the right to form associations and unions. An example of forming union or association may be given to the legal provision of forming registered societies under the Societies Registration Act 1860 and also the state laws like Manipur Societies Registration Act 1989. A society means an association of persons which relate to, amongst others, any charitable purpose including care and relief of orphans or of aged, sick, helpless or indigent persons, and any other association having its object as may be notified by the state government as being beneficial to the public. Some legislations like the Consumer Protection Act 1986, the Right to Information Act 2005 made mention about the role of the NGOs. So in this discussion, among the various NGOs, some human rights NGOs which are entrusted by some law relating to protection, promotion and upholding of the human rights, and their pressures upon the statutory bodies which relate to enforcement of human rights shall be met. Statutory bodies which have direct relationship with protection of human rights. In this regard, the Protection of Human Rights Act 1993 is passed in order to provide for constitution of a National Human Rights Commission, State Human Rights Commission for better protection of human rights. So these human rights commissions are statutory bodies to function under the Act for better protection of the human rights. The term human rights is defined to mean the rights relating to life, liberty, equality and dignity of individual guaranteed under the Constitution and international covenants which are enforceable by the courts in India. So applying this definition, human rights NGOs are those non-governmental organizations, whether a registered society or otherwise, which work for upliftment, implementation and promotion of human rights to life, liberty, equality and dignity of individuals in their relationship with the statutory bodies. Statutory bodies relating to human rights. In this aspect, let us find out some illustrations. The Consumer Protection Act 1986 is an act to provide for better protection of the consumers and to make provisions for establishment of statutory bodies of consumer councils and other authorities of the District Forum, the State Commission and the National Commission for Settlement of Consumer Disputes. The Act seeks to promote and protect the rights of the consumers. Under this Act, the role of the NGOs, that is, voluntary consumer associations, are authorized by the Act to play a very significant role in the protection of the rights of the consumers, whose rights are invaded by the traders or service providers. In case when the right of the consumers is invaded, the Act permits such a consumer to file complaint against the trader or service provider. Under Section 12 of the Act, a complaint in relation to any goods sold or delivered or agreed to be sold or delivered or any service provided or agreed to be provided may be filed with a district forum by any recognized consumer association, whether the consumer to whom the goods sold or delivered or agreed to be sold or delivered or service provided or agreed to be provided is a member of such association or not. A recognized consumer association means any voluntary consumer association registered under the Companies Act 1956 or any other law for the time being in force. In this manner, the role of an NGO, that is, voluntary consumer association, becomes significant in presenting complaints on behalf of the affected consumer to maintain an invaded right of the consumer by knocking the door of the statutory body, that is the district forum, the state commission or the national commission, whichever is appropriate. Next, we may also discuss another aspect. The Maintenance and Welfare of the Parents and Senior Citizens Act 2007 is a law to provide for more effective provisions for the maintenance and welfare of parents and senior citizens, guaranteed and recognized under the Constitution. A senior citizen, including parent who is unable to maintain himself from his own earning, shall be entitled to make an application which may be made against his children and relatives. The application may be made not only by the senior citizen or a parent, but also by any other organization authorized by him. So, this is another instance where an NGO may extend useful service to present the cases of aged persons before a statutory tribunal is permitted under the Act. In defining the nature of an NGO, broadly, a trade union registered under the Trade Unions Act 1926 may also come within the definition of an human right NGO. As a trade union means a combination formed primarily for the purpose of regulating the relation between the workmen and employers, or between workmen and workmen, or between employers and employers, which is for imposing restrictive conditions on the conduct of any trade or business. The general funds of a registered trade union may be spent for the prosecution or defense of any legal proceeding to which any member thereof is a party, when such prosecution or defense is undertaken for the purpose of securing or protecting any rights of trade union as a human right NGO in its relation to a statutory body. An example will be cited by referring to the Payment of Wages Act 1936. Under Section 15 of the Act, the state government is under obligation to appoint an authority to hear and decide all the claims arising out of deduction from the wage or delay in payment of wages of persons employed or paid in that area, including all matters incidental to such claims. The authority is a statutory body where proceedings would be initiated for securing and protecting the rights of the workmen who are not paid or delayed by the employers. The workman who initiated the proceeding would be strengthened tremendously, being backed by the trade union in which he is a member. Even funds could be spent from the trade union. Thus, a trade union has a significant role to play in protecting the right of an affected workman before a statutory body which is established by the state government. A modern trend in law can be seen in the constitution of many commissions by and under numerous legislations. For example, the National and State Human Rights Commissions under the Protection of Human Rights Act 1993, the Manipur State Commission for Women Act 2006, and the Commissions for the Protection of Child Rights Act 2005, etc. These are the commissions for protection of human rights. In all these acts, the commissions are established as the Human Rights Commission, the Women Commission, and the Child Rights Commission. There is one common function of these commissions, that is, to inquire into complaints and take suo motu notice of the matters relating to deprivation or violation of the human rights, violation of women's rights, and violation of the child rights, as the case may be. Even though individuals can come to the commissions to initiate complaints for violation of rights, due to ignorance of the general people, the benefit of the commissions cannot be availed of. Here the role of the human rights NGOs would be significant. Complaints before these commissions could be initiated by such human rights NGOs, and mostly in such cases where the mass has been affected, an NGO which is formed for the protection of human rights would find a chance to come forward for the protection of the rights of the mass. Well, friends, let us cite an illustrative case. The National Consumer Disputes Redressal Commission is established and constituted under the Consumer Protection Act 1986, having its seat at New Delhi. It is also known as, in short, National Commission, which is empowered by the law to entertain consumer complaints of the value above rupees 1 crore, having its jurisdiction throughout India. A consumer complaint is initiated by a voluntary consumer association called Consumer Unity and Trust Society against the Union of India, which was filed before the National Commission, being a statutory authority to adjudge consumer complaint. The facts of the case are that in a place at West Bengal, innumerable persons suffered severe disability as a result of consumption of the adulterated rapeseed oil. A complaint was initiated by the Complainant Society, which is formed for the protection of the rights of the consumers. The complaint was initiated for the affected victims by the Consumer Association as a relator of the people affected by filing a complaint before the National Commission Delhi for redressal of the grievances suffered by the victims. In the course of the case proceedings, the state of West Bengal assured to implement the works for the rehabilitation and treatment of persons affected by the tragedy whose names have been listed in the medical expert board's report, which was on record. The case was reported as Consumer Unity and Trust Society versus the Union of India and others. In the law report 1986 to 1994, Consumer, page number 736 of the National Commission. The National Commission termed the incident to be a very unfortunate humanitarian problem. The outcome of the complaint is that ex gratia payments are directed to be made to those who are listed as very severely affected and severely affected. The government of West Bengal and the Calcutta Municipal Corporation, in compliance with the order, complied with the payment. The Commission also directed to fix a reasonable amount of disablement pension, education grant and transport grant to be paid to the victims. The disablement pension, education grant and the transport grant to be continued to be paid monthly to the concerned victims of the tragedy until they are certified by the medical authorities that they have been restored to the state of normalcy. The Commission gave further direction about one victim who was a legal practitioner and was in judicial service of the state. He was very severely affected by the tragedy as he was unable to stand up or move about without external assistance, as his both legs are partially paralyzed. The state government agreed to provide for him a motorized tricycle and give transport grant in addition to providing him disablement pension. The Commission also directed the state government to provide the victim further with some legal works like drafting, which he can do in sitting position in order to ensure him some income. As regards treatment of the victims, it has been directed that the equipments and the types of the treatment which are required for each victim will be made available free of charge. The supply of the medicines and the protein supplements should be continued until the medical officer considers, after examination of the patient, that they do not require any longer the administration of such medicines and health supplements. The Commission's direction regarding the victim who have passed away as a result of the consumption of the adulterated rapeseed oil, the complainant society was to make a representation in the state government, and in such an event, the state government was to make sympathetic consideration. As regards the victims who suffered severe neurodeficit due to cerebral palsy, such patients are to be given free medical treatment and also disablement pension, which is to be continued until the time such patients come from their extreme disability. The National Commission expressed a word of appreciation to the public-spirited gesture of the Consumer Unity and Trust Society, a consumer organization which enabled to redress, to a limited extent, the enormous agony and suffering of the unfortunate victims of that oil tragedy. Friends, we can conclude now by mentioning that Even though we live under a system of democracy to ensure natural obedience and cooperative existence, it becomes the need of the hour to ensure as to who will watch the watchman. The answer is that non-governmental organizations can do that as regards their relationship with the statutory bodies. Regarding protection of the human rights, the statutory bodies like commissions and other quasi-judicial bodies would be essential for their assistance and cooperation in the matters of rendering judgments affecting the public. Knocking the door of justice is expensive, time-consuming and cumbersome, and as such, modern trend of legislations exhibit introduction of the statutory bodies, empowering them to redress the grievances of the public. Therefore, besides constitutional provision to confer freedom to the citizen to form association or union, some legislation have allowed and indicated the role of the non-governmental organization, and it is likely that it will increase in the years to come as sincere service both of the NGOs and the statutory bodies is the need of the hour in order to uphold the human rights, which is coupled with duty towards the society. So friends, this much for today. Thank you very much.